You know, it'd be really great if whenever the Supreme Court said something, all of the other courts would just jump. Sorry, it doesn't work that way, and I'm going to explain that to you, because we just had that amazing result in Cox v. Sony, the result we'd been waiting for 6 years. Finally, a vindication. All the crap we've been put through for the last 25 plus years. Sorry, no, you don't get to do that. And that was all based on contributory copyright infringement, which is exactly what we have here in Entrepreneur v. Meta. Meta made a motion to dismiss the case, and this is Judge Chhabria denying it. But as we'll see, Chhabria hasn't quite got the message yet. This is only a 3-pager. We're only going to look at page 2 of it, because we're going to see here how much Cox is going to change once the lower courts finally get the memo. So the Entrepreneur case is again about the whole BitTorrent thing. They must have ceded back their books and therefore contributory infringement, blah, blah, blah. Meta just wanted him to kick that right out. Judge Chhabria denied it, saying, Entrepreneur's allegations are also sufficient to Meta's knowledge. The cases cited by Meta discuss this heightened knowledge requirement in the context of the defense established in Sony. That's the Betamax case. That's the one where we were almost not allowed to have VCRs, which limits secondary liability for copyright infringement for sellers of items capable of substantial non-infringing uses. You know, like BitTorrent has. So much bandwidth being saved by, for example, Linux distros because of people downloading through BitTorrent and helping out, giving some of their bandwidth to others. It's really amazing technology. It can be used to infringe, but it can also be used for non-infringing uses. But he says actual knowledge of specific infringement overcomes the Sony defense. And then a little lower he says, but the general scienter requirement for contributory liability, that is, the standard that applies when the Sony defense is not applicable, so he's already saying you can't use the Sony defense, is that the secondary infringer know or have reason to know of direct infringement. That is not what the Supreme Court just said. The Supreme Court knocked that down. They must have participated in or actively encouraged the infringement. Mere knowledge is not enough. That's verbatim from the Cox v. Sony ruling. Not know or have reason to know, participate or actively encourage. So Chhabria hasn't read the ruling apparently. That standard is satisfied by Entrepreneur's allegations that Meta deliberately downloaded copyrighted works using BitTorrent, which users know requires uploading the works to the torrenting network, and that Meta knew or had reason to know that members of the network were infringing as a result. Again, completely the opposite of what the Supreme Court just said. Entrepreneur alleges that Meta was a direct participant in a file-sharing system that inherently facilitates third-party infringement. Courts have found similar allegations sufficient in the peer-to-peer file-sharing context. Yeah, but those courts are all subordinate to the Supreme Court, aren't they? Alright, let's be fair to Judge Chhabria and explain what's really going on. Cox just came down the pike. This ruling might have been being worked on while all that was happening. And certainly all of the briefings about the motion to dismiss were before the ruling. So the judge has to kind of go by those briefings. It'd be nice if, when he talked about the general scienter requirement, there would have been a perfect opportunity to say what the actual requirement is now. But it wasn't briefed. It probably was. He was probably working on this while the decision came out. So there's a lag. It takes a while. And if you're saying, hey, there was just the Supreme Court ruling saying they can't do this, why are they doing it to me? You gotta give them a minute. You gotta actually go through and say, hey, look, here's the Supreme Court ruling, which I expect Meta to do. They might well come right back with another briefing saying, hey, you made it based on knowledge. The Supreme Court just said you can't do that. Reconsider. Either a new motion to dismiss or a motion for reconsideration. At least get it on the record that that's what's happened. Either way, I think the case is going to go forward because he is allowing it to go forward on the DMCA claim about the CMI. That was defeated at summary judgment over in Cadre, but they're not at that point yet. This is still the pleading stage. So even if they don't prevail, motion to dismiss, it's a really low bar you have to get over. You basically have to not trip over a cable and you pass the motion to dismiss stage. Very low hurdle. So that's another possibility, is when they get to the summary judgment stage. Not only will those same CMI arguments come into play, and Chhabria might well throw those out, the contributory infringement claim might be thrown out as well because of Cox v. Sony. We can only hope. I just wanted to point that out, though. Things are going to take a little while to change. It takes a while for the lower courts to get the message. Sometimes the lower courts just keep doing what they're doing until the circuit court says, wait a minute, no. So there might have to be an interlocutory appeal. Who knows? We'll just have to see. But that's how it works when you have a Supreme Court ruling. Changes are slow, even once the Supreme Court has spoken. But that concept of knowledge being enough for contributory infringement is now invalid from the start, always was, because that's how Supreme Court rulings operate. So all of the cases out there that are based on it or have just recently been based on it, a lot of people are going to have to be putting forward new motions based on Cox v. Sony. So it'll be really interesting to see what it does with these anti-AI cases. And this is one where we might actually see it soon, because right here, we're seeing Judge Chhabria go directly against what's in Cox v. Sony. So we'll keep an eye on it and let you know how it goes. Thank you so very much for watching. Comments for the comment god, shares for the share throne. Please hit like, subscribe, and the bell. And of course, donate.bogosity.tv always keeps me doing this with one-time donations or regular support. Thank you so very much for watching. Until next time, stay strong and be free.